Hello, my name's Dr. Brett Davies. Your will can be challenged by certain groups of people. Parents, people you sleep with like a husband and wife, a mistress, a gay partner, your children, children you adopt, stepchildren in some jurisdictions, grandchildren, and in New South Wales, as some other states, it's even people you maintain and look after in your household. So how do you stop someone from challenging your will? It's your will, it's your money, and you want to decide where it goes to. It's not that simple. See, the making of a will is a privilege given to you by an Act of Parliament. It's not a right, it's not a natural right, it's a privilege given to you, and the courts are very happy, well, not actually happy, but courts are prepared to change your will, to alter your will, if they think you have not sat as a wise and just testator. So if they think you've been a bit silly, if they think you have not treated the family properly, then they will carve up your will differently. Well, I'm not going to tolerate that. I'm not going to do that. Well, if you're not happy with that, give away all your assets now. You can do that. You can give all your assets away before you die. And then nothing's in your will and nothing can be challenged. But you better make sure you die, because you'll have no assets and those children are not going to give it back to you. So most of us will die with assets because we don't know when we're going to die, most of us. Well, how can I reduce, at least Dr. Davies, give me something here. How can I reduce the chance of people challenging the will? Well, let's make it this way. If you're leaving everything equally to your children, it's probably unlikely someone's going to challenge your will. But let's say you decide to cut your children out, which is, by society standards, is an unusual thing to do. You can do it, but it's not considered usual. It's not considered usual. If you have someone that might well challenge the will, maybe you're a de facto relationship, you don't want them to get anything, you can name that person in the will under what they call a considered person clause. All it says is this: I've considered my obligations to Robert John Smith, and I've decided that I've given that person enough. So it's very innocuous, it doesn't hurt or anything, but it stops that person saying, oh, the testator, the will maker just forgot me. So a considered person clause is worthwhile putting in your will. You can see in the sample document what it looks like. Now if you need some legal advice, more legal advice, then contact us. We're a law firm and we can help you answer this question.